Going to therapy feels, I don't know, it feels like entering this purely safe, secret bubble. You know what I mean? You walk into that quiet room, the door clicks shut, and suddenly you are just entirely insulated from the outside world.
Oh, absolutely. Yeah.
It's a space where you can say your absolute darkest thoughts without any judgment. But behind the scenes, that bubble is actually held together by this highly regulated, really high-stakes rule book for basically being a good person.
Right, right.
And it is a rule book where the rules occasionally completely contradict each other. And breaking just one of them could literally end a counselor's career or, land them in court.
Yeah, in front of a judge.
Exactly. So today, we are taking a look at this hidden tightrope that mental health counselors walk every single day. We are doing a deep dive into the intersection of ethics, morals, and the law in the counseling profession.
It is such an important topic.
It really is. Our mission today is to decode these invisible rules for you and show you that counselors do, well, a lot more than just listen and nod. They operate within this massive, complex framework that is actually designed to keep you, the client, and society at large entirely safe.
It really is the absolute definition of professional muddy waters. I mean, that quiet room you mentioned is actually this wild nexus of obligations that are constantly shifting.
Yeah.
So to understand how counselors maintain that space, we first have to realize that making decisions in that room is rarely as simple as just, doing the right thing.
Which, that phrase alone, doing the right thing, it feels like a trap.
Oh, total trap.
Because before we can get into the actual drama of real-world counseling dilemmas, I feel like we need to define the basic rules of the game here. We tend to use words like moral, ethical, and legal interchangeably in just everyday conversation. But my guess is that confusing those three terms in a clinical setting could be disastrous.
Disastrous is putting it mildly. It is a phenomenal way to lose your medical license.
Wow.
Yeah. So we really have to separate those three pillars. Let's start with morality. Fundamentally, morality is about the judgment of action. It's the arena where we use words like, good, bad, right, or wrong.
Right.
But morality is deeply tied to personal beliefs, philosophical disciplines, and the specific societal or religious context you grew up in.
So it's essentially your personal compass, which means my morality might look completely different from yours just based on where we were raised.
You're hitting on the core tension right there. Because morality is so subjective, a profession really cannot regulate itself solely on it.
That makes sense.
Right. And that is where ethics come in. Ethics are these normative standards that govern a very specific relationship between individuals.
Okay.
So in this case, professional ethics govern the relationship between a counselor and a client. The American Counseling Association, or the ACA, they publish this massive, comprehensive code of ethics.
And these aren't just polite suggestions, I assume.
No. They are rigorous, agreed-upon rules. And they're designed to do a few things: protect the public from incompetent practitioners, protect the profession itself from government overreach, and, provide a concrete guide for behavior.
Which I guess brings us to the third pillar, which is the law. And I imagine the law doesn't really care much about your personal moral compass or your professional association's guidelines.
The law does not care at all. The law is the precise codification of governing standards established by society. It's basically the absolute floor of acceptable behavior designed to ensure legal and moral justice.
So it's the bare minimum.
Exactly.
Yeah.
If ethics are the standards of a specific profession, the law is the strict mandate of the state.
Let me try to map this onto an everyday scenario just to see if I'm tracking this right.
Go for it.
Okay, so imagine you borrow a friend's car.
Okay.
Morality is feeling guilty if you spill coffee on the passenger seat because you personally know it was a careless thing to do. Ethics are the unwritten kind of normative rules of friendship, like making sure you fill up the gas tank before you hand the keys back.
I like this. Yeah.
But the law is the speed limit you are physically forced to obey while you are driving that car.
That analogy holds up perfectly, especially when you start to see how those three pillars inevitably crash into each other.
Yes, they definitely do.
Oh, constantly.
Yeah.
Because what is strictly legal might be considered deeply immoral by a large portion of society. I mean, think about historical laws that enforced segregation.
Right.
They're perfectly legal, codified by the state, but profoundly immoral, which ultimately drove societal upheaval.
Or, just sticking to the car analogy, it's completely legal to return your friend's car with an empty gas tank.
Yep.
But it's highly unethical for the friendship, and it's probably going to end that relationship.
Exactly. And that friction is why the ACA's Code of Ethics, as thick as it is, isn't some magic index where a counselor can just, look up the answer to any human problem.
Because life is too messy.
Right. Ethical codes are inherently general and idealistic. They cannot possibly address every single cross-cultural issue, every new technological dilemma, or just every weird, nuanced family dynamic that walks through the clinic door.
Hmm.
The code forces counselors to rely on critical thinking.
Which begs the question, if the official rulebook falls short of covering every messy human situation, what is guiding the counselor? They have to have some kind of deeper compass to navigate those gray areas, right?
They do. They rely on the 6 core moral principles of the helping profession.
Okay.
Think of these as sort of the philosophical bedrock beneath the official rules.
Shame on me.
So the first two are beneficence and non-maleficence. Beneficence basically means doing good and actively promoting the well-being of the client.
And non-maleficence sounds like the classic Hippocratic oath first, do no harm, like avoiding actions that risk hurting the client.
You got it, yep. The third is autonomy, which is respecting the client's freedom of choice and self-determination.
Okay, so letting them make their own decisions.
All right. Fourth is justice, meaning fairness and providing equal treatment to all people, regardless of their background.
Sure.
Fifth is fidelity, which is faithfulness, like honoring your commitments and keeping your promises to the client. And finally, veracity, which simply means truthfulness and dealing honestly with the people you treat.
Okay, wait, let's unpack this, because I see a massive collision coming here.
Oh, I bet you do.
Let's look at autonomy. The client's freedom to make their own choices and pit it directly against non-maleficence, the counselor's duty to prevent harm.
Okay.
Say a client comes in and announces they're going to make a perfectly legal but absolutely destructive life decision. Like they're going to empty their children's college fund and blow it all at a casino in Vegas.
Wow. Yeah.
Or they're going to just abandon their family to marry someone they met on the internet yesterday. Autonomy says the therapist has to respect their freedom of choice.
Right.
But non-maleficence says the therapist has a duty to prevent harm. How does a human being reconcile that in real time?
I mean, that scenario is the ultimate professional crucible. When those principles collide like that, a counselor cannot just go with their gut instinct. They have to move up what researchers call a developmental continuum of reasoning.
A continuum of reasoning. I'm guessing that means they don't start out making perfect philosophical choices on day one of their career.
No, very few do. Novice counselors, or even experienced ones who are just, burnt out and trying to survive a Tuesday, they often operate from a punishment orientation.
What does that mean?
It means they make decisions based solely on avoiding getting in trouble, like avoiding a lawsuit or not breaking a strict rule.
Ah, okay. Just covering their own bases.
Exactly. But as a counselor matures, the goal is to evolve toward a principle orientation. This is the highest stage, where ethical decisions aren't driven by fear of punishment, but by deeply internalized ethical standards and a conscious weighing of those 6 principles we just talked about.
So they aren't sitting there sweating, asking, will I get sued if I let them go to Vegas? They are asking, what is fundamentally the most just and helpful path for this specific human being?
Right, which requires a highly systematic, step-by-step decision-making model. When faced with that Vegas scenario, a principle-oriented counselor identifies the problem, consults the ACA code, reflects on those 6 moral principles, consults with senior colleagues to check their own biases.
Wow, that's a lot of steps.
It is. And then they meticulously evaluate potential courses of action before ever uttering a single word of advice. It is the complete opposite of a knee-jerk reaction.
Well, let's take these lofty philosophical principles and see what happens when flawed, everyday human beings enter the picture, because the tension between survival and ethics has to play out in clinics every day.
It really does. I was reading recently about a clinical scenario from the source material that perfectly illustrates this.
Yep.
We can call the counselor Carl.
Okay, Carl.
So Carl decides to quit his job at a large community mental health agency, to strike out on his own and start a private practice.
Good for Carl.
Well, as with any new business, things are incredibly slow. The phone isn't ringing. He is really struggling to pay his office rent.
Oh, no.
But then suddenly, his old agency, the one he just left, sends him 2 referrals for anger management counseling because they are completely overbooked.
Okay, I see where this is going.
Carl knows the ethical standard dictates he should refer these clients back into the agency system or to a more appropriate, affordable community resource. But considering his dire financial situation, he intakes the clients for his new private practice instead.
And charges them.
Yep, charging them his private rate simply because he needs the revenue to keep his lights on.
I mean, to anyone in the corporate world, that just feels like poaching customers from your old boss. Maybe you'd get a nasty email or a cease and desist. But in therapy, is that a formal breach of ethics, or is it just kind of aggressive business?
Oh, it is a severe breach of professional ethics. Absolutely. Primarily because of something called a hidden agenda. The ethical guidelines demand that counselors operate openly and transparently. By taking these clients for his private practice to solve his own money problems, Carl is allowing his personal needs to overshadow the client's best interest.
So his clinical judgment is just entirely clouded by his wallet.
Yes, and that creates what we call a multiple relationship or dual relationship. The client sitting on the couch, they think they're just getting anger management help. They trust Carl implicitly, but Carl is secretly using them as a financial lifeline.
That feels so gross when you put it that way.
It fundamentally compromises the principles of fidelity and veracity we just talked about. He is no longer dealing honestly with them.
It makes you wonder how often a therapist's own stress bleeds into their treatment plans. Which actually leads me to another scenario I want your take on.
Sure.
Let's imagine a brand new counselor. We'll call him Fred.
Okay, Fred.
Fred just landed a job at an outparent mental health facility. He is eager to please, trying to make a good impression, but his supervisor calls him into the office and tells him to artificially inflate his client case numbers by 10% on his weekly reports.
Oh, boy.
Yeah. The supervisor explains that the clinic needs to show higher numbers to secure a vital state funding grant. When Fred pushes back, the supervisor explicitly tells him to forget ethics and think about your paycheck.
That is a terrifying position for a new professional. Fred is facing immense pressure from a figure of authority to commit systemic fraud.
If I'm Fred, my head is spinning. If he refuses, he probably gets fired on week 2, right? Does he just anonymize the data and hope for the best? Does he quit quietly? What does he do?
Quitting quietly might save his own skin, but the ACA code actually provides a strict mandate for handling unethical colleagues. You are expected to first approach the colleague, even a supervisor, directly to attempt an informal resolution.
Wait, seriously?
Yes, you have to point out the ethical violation and ask them to correct it.
That requires immense moral courage. Confronting the person who signs your paychecks and basically accusing them of defrauding the state.
It is completely daunting. But if that informal approach fails, or if the supervisor doubles down, the counselor is ethically mandated to escalate. They must report the supervisor to a state licensing board or the ACA ethics committee.
So staying quiet just isn't an option at all.
Not in the eyes of the profession. Ignoring the behavior is not considered a neutral act. Overlooking it condones the behavior and triggers a dangerous psychological mechanism, the normalization of deviance.
The normalization of deviance.
Yeah, it's a slippery slope. If a clinic normalizes a 10% inflation of numbers today, they are rewiring their organizational brain to accept fraud. What are they overlooking next year? Falsifying patient progress. Billing for sessions that never happened. A counselor's ultimate loyalty is to the integrity of the profession and the public trust, not to their boss's funding scheme.
Wow. Okay, so Carl and Fred were dealing with professional boundaries and financial fraud. High stakes for their career, certainly. But let's escalate this even further. What happens when the stakes move from professional drama to literal life and death? When does a counselor absolutely have to break that safe secret bubble we talked about at the beginning?
To navigate that, we really have to differentiate between two concepts that sound similar but operate entirely differently. And those are confidentiality and privileged communication.
I always just assumed those were synonyms for keeping a secret.
Many people do, but confidentiality is an ethical duty. It is the counselor's foundational pledge to protect client information from being shared casually. It's the trust that makes the therapeutic relationship even possible.
Okay.
Privileged communication, on the other hand, is a strict legal concept. It is the client's legal right to keep their therapeutic secrets out of a courtroom. It prevents a judge from forcing a counselor to testify against their client on the witness stand.
Ah, I see. So it's akin to a priest's confession box, or like attorney-client privilege. We assume everything said inside that box is totally protected from the police and the courts.
That assumption was the norm for decades. But that protection is not absolute. The turning point for the entire mental health profession was this landmark legal tragedy in 1976 known as the Tarasov case.
The Tarasov case, yeah, the background of this is haunting.
It really is.
So imagine you are a therapist at the University of California, Berkeley. A voluntary outpatient named Prasenjit Poddar is sitting across from you. And during a session, he explicitly tells you that he intends to kill his former girlfriend, Tatiana Tarasov, as soon as she returns from a summer trip. What do you do?
I mean, the psychologist in that case was placed in an impossible bind. He actually took the threat very seriously.
Yeah.
He weighed his ethical duty of confidentiality against the moral imperative of non-maleficence preventing harm.
Right.
And he decided to break confidentiality and warned the campus police, asking them to evaluate Poddar.
Which sounds like he did exactly the right thing.
He tried. The police detained Potter, questioned him, but ultimately decided he seemed rational and promised to stay away from her, so the police released him.
That's just wild.
It gets worse. Potter, feeling betrayed by his therapist, stopped going to counseling. And 2 months later, he followed through on his threat and murdered Tatiana Tarasov.
Oh my gosh. Her parents ended up suing the university, the police, and the health service, right?
Yes, and when that lawsuit reached the California Supreme Court, the decision fundamentally changed the rules of therapy forever.
How so?
It sent shockwaves through the entire medical community. The California Supreme Court ruled that a therapist has a duty to protect the public that overrides any obligation to maintain client confidentiality.
Wow.
Yeah. The court declared that the therapist should have taken further steps, like warning Tatiana or her family directly. The most famous quote from that ruling established a new legal reality, which was, "The protective privilege ends where the public peril begins."
That is heavy. To bring back my confession box analogy, the Tarasov ruling basically stated that if a client confesses to planning a future harm to a specific person, the priest isn't just permitted to break the seal. They are legally obligated to smash the box open, alert the authorities, and warn the intended victim.
Exactly. The ripple effect was massive.
Yeah.
Counselors today are legally mandated to break confidentiality in several specific high-stakes instances.
Like what?
Cases of suspected child abuse, elder abuse, imminent danger to self, imminent danger to others, and when they receive specific court orders.
So I want the listener to really internalize this. Imagine you are that therapist today. That safe bubble you promise your clients has a trapdoor built into the floor.
A legally mandated trapdoor. If a client tells a counselor they're actively abusing a child, the counselor cannot just sit back, stroke their chin, and explore the client's feelings about the abuse.
Right.
The law dictates that they must immediately report it to a state welfare office. This is where the law forcibly overrides professional ethics to ensure moral justice.
But think about the incredible weight of this duty to protect. Therapists are living under the constant crushing threat of liability. I mean, if they don't report a threat and someone gets hurt, they get sued for negligence.
Yep.
If they report a threat unnecessarily and ruin a client's reputation, they get sued for breaching confidentiality. How do they legally protect themselves while navigating this absolute minefield?
They protect themselves through meticulous, almost obsessive documentation.
Documentation.
Yes. This brings us into the realm of liability and malpractice. Malpractice is defined as acting unprofessionally or negligently, and the consequences range from civil lawsuits to criminal charges.
Yeah.
And the most complex area of liability, where documentation is absolutely critical, involves treating minors.
I'd imagine that's a legal nightmare because kids can't actually consent to their own medical treatment, right? The parents hold all the cards.
That is exactly the crux of the issue. Minors generally do not have the same legal rights to privacy as adults. In most jurisdictions, parents or legal guardians have the absolute right to know what is happening in their child's treatment. A counselor usually needs explicit, informed consent from the parents to even speak to the child in a clinical setting.
Which means the parents can, at any point, demand to see the counselor's private notes.
And if the parents get divorced, or if Child Protective Services get involved, those notes are going straight to a judge. This is why objective record keeping is vital.
Oh.
Let me give you a scenario from the source text that highlights how easily this goes wrong. Think about a counselor we'll call Diane.
Okay, Diane. What did Diane do?
So Diane keeps all her client records digitally on her computer, which is common practice. One day, she receives a court order, a subpoena, requesting the full file of a particular client who's involved in a legal dispute. Diane reviews her digital notes before sending them off. While reading, she realizes she made a factual mistake in an entry from 3 months ago, or perhaps phrased a clinical observation poorly. So she just opens the document, highlights the old text, edits the entry to fix the error, hits save, and sends it to the court.
Wait, I have to push back on this because we all edit our digital documents constantly.
Sure we do.
Right. If I send an email with a typo, I fix it in my drafts. If a therapist is just going back and fixing a typo or clarifying a messy thought in their own personal notes, why is this a massive issue? It's literally just hitting the backspace key.
Because you have to understand the legal status of those notes. Client records are not a counselor's personal diary or a rough draft of a novel.
Okay.
They are highly protected legal documents, often governed by strict federal privacy laws, like the Family Educational Rights and Privacy Act, or FERPA, especially if the counselor works in a school setting.
So they aren't just notes to help the therapist remember things. They are medical evidence.
Yes. And altering medical evidence retroactively, especially after receiving a subpoena, is not just bad practice. It is a criminal act. It is considered tampering with or destroying evidence.
Oh, wow. Because it alters the timeline of what the therapist knew and when they knew it?
Precisely. If Diane needed to correct an error, the strict legal and ethical standard is to leave the original entry exactly as it was written on that day and create a brand new, currently dated entry explaining that she is correcting a past mistake.
By simply hitting backspace and rewriting history, she essentially forged a legal document.
She committed fraud. Clients have an explicit legal right to see an accurate reflection of their records. If a counselor alters them to look more competent for a judge or to hide a mistake, they are violating the client's rights. Supervisors hammer this visualization into new counselors. You must type every single sentence, acting as though it will eventually be projected on a screen and read aloud in a courtroom, with a client and a judge sitting right next to you.
That drastically reframes the entire picture. I mean, when you are pouring your heart out and you see the therapist jotting things down on their notepad or typing on their laptop, they aren't just journaling, they are drafting a legal document that could be scrutinized by a state.
It is a profound responsibility. Every single word matters, because every word carries legal weight.
Taking a step back and looking at this whole journey today, it's clear that being a mental health counselor requires a skill set far beyond just being a good, empathetic listener.
Oh, absolutely.
It is a continuous, exhausting, high-wire act. Every single day, with every single client, they have to balance their own internal moral compass, the rigorous standards of the ACA Code of Ethics, and strict, unforgiving legal mandates like the Tarasoff duty to warn.
It requires an incredible amount of critical thinking and, honestly, moral courage. They're holding the fragile well-being of the client in one hand and the safety and legal expectations of society in the other.
So the next time you, or someone you know, sits down on a therapist's couch, I hope you understand the massive, invisible framework operating in that room. The safety of that therapeutic space isn't a happy accident. It is guaranteed by boundaries that have been forged through decades of intense ethical debates, Supreme Court rulings, and really hard-learned lessons.
It's a protected space, precisely because the rules governing it are so deeply scrutinized.
But as we wrap up this deep dive, I want to leave you with one final thought to chew on. Just as the counseling profession finally seems to have figured out the rules for the physical counseling room, modern technology is blowing the whole framework wide open again.
Oh man, the absolute wild west of cyber counseling.
Yes. Think about the dilemma this creates. If you are sitting in your living room in Texas, receiving telehealth counseling from a licensed therapist sitting in their office in New York, and those two states have completely conflicting laws regarding confidentiality or the duty to warn, whose rules apply?
It is a massive legal and ethical gray area. If the Texas client threatens someone, does the New York therapist follow New York's mandate to report or Texas's specific privacy laws?
And who really owns your therapeutic secrets when they are being transmitted as data packets through third-party servers across state lines? That purely safe secret bubble we talked about at the very beginning. When you move therapy to the internet, that bubble suddenly has a lot of transparent walls and invisible third parties. It's a complex frontier, and it's definitely something to mull over the next time you log on for a telehealth session. Thank you for joining us on this deep dive.